Good afternoon, everyone, and welcome to Cannabis Live. It is June 14th. We are the Cannabis Legal Group, coming at you week after week with the most up-to-date news, both in the state and federally. My name is Nicholas Galendez, and this is Jennifer Domingue. Today we're going to kind of talk to you about one big subject, that being the Medical Marijuana Facilities Licensing Act, recent changes to the application form and disclosures. We're also going to give a little bit of updates about the Medical Marijuana Act, as far as just numbers about total patients in the area, as well as some adult use updates, which are, that program is going to be rolling out very shortly throughout the summer into the fall and the end of the year. But first, before we do that, as always, the Cannabis News with Jennifer Domingue.
For this week's news, we actually had a number of very exciting developments happen across the nation. The first one, I think, is the United States Postal Service has provided a policy update stating that it is now legal to mail hemp-derived products, including CBD, through the United States Postal Service. In fact, the policy update further stated that not only is it legal to do this as long as the mailer complies with all federal and state regulations and laws regarding hemp, but also retains records for to show that hemp product is legal and in compliance with local and federal laws. So this is actually rather surprising, because most people were expecting that for the United States Postal Service to be a federal agency and allow for hemp and hemp-derived CBD to be mailed, you may have to sign a certification form or some sort of statement indicating what you're mailing and to assert that you are in fact in compliance. But the Postal Service is not requiring any of that and only requires you to retain records. So this is a very liberal and progressive step for the United States Postal Service. We commend them for this approach, and we'll look forward to seeing additional policy updates in regards to this in the future. Next up, we have updates from Nevada, where Governor Steve Sisolak signed a bill number 533 into law, which basically created a cannabis compliance board. This is unique because, as you may recall, Michigan recently removed our board, so now Nevada is instituting a board to govern all of their cannabis facilities. Furthermore, this same bill prohibits local governments from issuing social consumption licenses for up to 2 years. So that effectively leaves the entire state of Nevada, including Las Vegas, without having any social consumption license opportunities until 2021. This looks like it is a direct response to the Las Vegas City Council that voted in May to allow for social consumption business licenses and land use regulations to be created. So it looks like the state of Nevada is now creating a position for themselves where they are in direct contravention to what the City Council for Las Vegas has said, and has made more of a definitive statement in that regard. And finally, we want to talk to you about how marijuana is becoming so mainstream that it is actually surpassing McDonald's and Starbucks in several municipalities. And I think we have a graphic to show you. So as you can see here, there's a graphic that was created by Marijuana Business Daily, and it shows the number of marijuana retail stores compared to Starbucks and McDonald's per 100,000 residents by city. And so Nick, I just wanted to talk to you about this briefly, because it looks like, especially with Portland and Denver, you can see that the marijuana stores are so densely populated there that it's way above Starbucks, and I feel like I see Starbucks on every street corner.
Yeah, and I mean, I think this is especially interesting just given the fact that, you have a lot of these green zones where it's pretty much a green oasis of different cannabis businesses. I mean, just for purposes of this conversation, gonna go ahead and make an assumption that, a lot of these are centralized in a lot of bigger cities, kind of to make that comparison right now. There's a lot of them allowed in Detroit. a lot of them that are going to be centralized in Flint, Bay City. And I think the influx and the kind of big first wave of businesses entering there, it kind of makes it very interesting, especially when you do kind of compare it to the numbers of coffee stores and fast food joints. I think there could be a lot to be said about the trend of kind of moving away from fast food into more healthy eating as well. But I think this kind of creates a big issue, though. I think the more the merrier to a certain extent, and I certainly think we're all pulling for a lot of more municipalities to come on board. It's the right decision to allow them, but I think it also creates some issues with operators and having to compete with so many businesses.
I would agree with that. What I'm seeing from these charts here is a very real congregation of like businesses, and then once you have a market that is so saturated, then you're going to be undercutting each other, trying to drive the prices lower. You're going to reduce your overall profitability, and you're not going to have as much overall success if you're in such an oversaturated market. And that's what I think especially Portland and Denver are coming close to, where it looks like Portland is several times higher than Starbucks, and that is significant. So, I mean, if you look at that graphic again, you can see how closely the numbers fall for Anchorage, Alaska, but when you look at Denver and Portland, again, marijuana isn't allowed throughout that entire state. It's going to be centralized in certain cities, in certain sections of those cities. So now you have dry zones where patients everywhere might not be able to have access in the more rural areas or areas of the city where they might not have public transportation. But you also have, on the flip side, an issue for the business owners now, where they are forced to go find real estate and conduct business in an oversaturated market.
And I think it's a little, the businesses or the municipalities that allow these businesses there want them to succeed. It's in their best interests. A lot of them are thoroughly vetting these candidates. But if the system that they've set up makes it so that, if I'm having to lower my prices because Jennifer has a store next door and she's getting more customers and has a lot more marketing capabilities, so on and so forth, I shut down immediately, and then another person comes in my place, and then there's 6 different stores next door and on the next main street. You're pretty much setting up these businesses to fail. So I think that there needs to be a good balance between planning. Just because you're allowing it doesn't mean you should allow it on every single storefront. It also doesn't mean you should just allow one. So I think that a good mix, meeting in the middle somewhere there kind of makes the most sense from both a city and a business operational standpoint. And so obviously a lot of these markets are going to cater to different residents. Portland might have different needs, and those residents might be going to these different cities for different storefronts for different reasons. And maybe the market does need 20 different storefronts per 100K residents, but I think just generally, especially as it starts up in Michigan, if the numbers are like this, I definitely think there might be a lot of turnaround as far as operators go, and we definitely don't want to have that happen given how much these licenses cost compared to potentially getting a Starbucks or McDonald's up and running and keeping it running.
Right, absolutely. So it'll certainly be interesting to see how the local economies adjust to having possibly oversaturated markets, and seeing how the economy will equalize over time and reach an equilibrium. But that's it for today's news, and as always, we'll be coming at you next week with the next week's news. All right, sorry about that, guys. A little bit of a technical difficulty there. We want to just kind of dive right in and talk to you about the Marijuana Regulatory Agency and how they held their first public hearing this past week. This is the first public hearing we've had since the licensing board was eliminated and the Marijuana Regulatory Agency was established. So the purpose of this public hearing was to provide updates on the agency and discuss upcoming changes that we can expect to see from LARA. They did report increased numbers in application processing and decisions issued compared to the medical marijuana licensing board. So they did show statistics to show that the new agency is moving at a faster rate of speed compared to the prior board. In regards to numbers, the Michigan Medical Marijuana Act, that's the patient and caregiver model, they did state that the new total amount for the patient numbers is 287,094 patients in the state of Michigan. We have one of the largest patient bases for states in the country, and this number just keeps growing. I am expecting, honestly, to see this number start to dwindle over time, because eventually people are probably going to stop getting their marijuana card and just purchase on the adult use platform. But I could be wrong. What do you think?
So I think, if you have a qualifying condition and a doctor is willing to certify, I think there's certain advantages to maintaining your patient status. One of those being lesser taxes. So they're going to tax your medicine less than they would adult use recreational product. The other distinction I think that still needs to be kind of fleshed out is driving. While we don't advocate driving on cannabis at all, there is a certain difference between an adult over 21 cannot drive, while impaired. There's a certain, right now, until there's a nanogram limit potentially for adult use, there's still kind of more protections for patients. And so I don't think that it'll be dwindling yet, especially because there haven't been that many municipalities that have opted in for adult use. So I think that even though stores will start opening, a lot of the product will be coming from patients from those medical facilities. So.
I would probably agree with that as well. Then the MRA decided to go into adult use and talk a little bit about what we can expect for emergency rules and the administrative rules surrounding the new adult use cannabis platform. So emergency rules, which are the initial guidelines we're going to be getting to see the overall structure of the adult use landscape. These have been much anticipated, and we haven't gotten a draft yet, but we are expecting them to be published later this month. These rules are going to establish additional license types and requirements, and basically provide an outline for what it'll take to file an application, what they will be looking for in a licensee, and any sort of restrictions or consequences for failure to follow those rules. So we're definitely looking forward to seeing what those rules will have. And then once the rules are issued, then we'll be looking forward to reviewing the paper applications. The paper applications will be structured in very similar format to what we see in the medical marijuana application. So that means we're going to have a pre-qualification step 1 section where it's a background check review, and we're going to be looking at the backgrounds of all of the business owners and the applicant entity. The step 2 is the facility application. So very similar structure to what the medical marijuana application structure is, but the unique requirements may vary. And so we'll definitely be keeping you posted on those once we have seen the emergency rules as well as the paper application. The state also indicated they are expecting to start accepting applications in the fall of this year, which is very exciting. They're moving much faster than I think either of us had anticipated. And so the law requires that they make a decision within 90 days of submitting a complete application. This is much faster than what we've seen for the medical marijuana side. So this is by statute. They have to give a decision within 90 days, which is nice. But again, we have to get through a 2-step process here. And so it's going to be a very fast turnaround. Keep in mind that for most of the license types offered, you're only going to have MMFLA licensees, so medical marijuana facility licensees will be eligible to apply. the state will be having a modified application process for this adult use application if you're an MMFLE licensee. I don't know what that process is going to look like yet. Again, you'll have to wait for the emergency rules, but we'll be sure to report on that.
So I have two things to kind of comment on before
Sure.
we do a little brief update on the last part of the hearing and really dig into the application changes. One is that I think the MRA has been practicing more recently than previously, and a lot of this, the changes we're going to talk about in the future are intended to, I think, meet that 90-day deadline for adult use. It used to be, based on the monthly meetings that we had from the licensing board, that it would take a long time just to process everything. And what we've seen as time's gone by, learning curve, the BMMR, BMR, and now the MRA has been doing a stellar job of kind of, really getting at what is needed to be looked at initially and really kind of digging deeper if needed. And what we can report is that we, from start to finish, we did see one of our clients get fully, step one approval within exactly 90 days, actually. Mm-hmm. So it can be done. It does mean a complete application. So if you don't do the work on the front end and you submit half of an application, there's going to be more than 90 days before you get a decision. But it's good to see them being efficient and streamlining the process, including these application changes. The second thing was me clawing back what I just said about patients and adults. It used to be that patients, and it still is, that they cannot drive while impaired. For adults, before the adult use law, there was a zero tolerance policy for having any of it in your system. So I take back what I said a little bit ago about whether or not people are going to be relinquishing their patient cards. I think that still is true. The answer is still that I think there will still be a good growing patient population, at least for now, just due to the lower prices and the more availability of medical storefronts. So those are my 2 cents. Just to kind of close off one of the more smaller topics that we had, the MRA did go over a little bit more about the administrative rules. So what they're going to do, as Jennifer mentioned, is release the emergency rules for adult use later this month, and then shortly afterward they're going to start working on refining both the MMFLA and adult use rules by kind of creating what they call topic-based rule sets. And so the one example that I think really worked when the MRA gave an example was, for lab practices and standards. Instead of having one set for medical, one set for adult use, they're kind of going to fold those both into one, which they called lab practices and standards. So instead of having to refer to two separate documents that might, or more or less say the same thing, they're going to kind of make it efficient again and look in one place if you're a testing lab, or look in another place if you're a marijuana establishment / provisioning center selling to the public. So I think that's going to help along the line and kind of flesh out more rules based on the license type versus the two different laws.
I completely agree with that. I think that especially if the state is considering having co-located facilities holding both a medical and an adult use license, the facilities are going to have a hard enough time keeping their point of sale systems straight and making sure that they're in compliance. It's going to make things much easier for them just to look at one topically related rule set rather than having to look at individual rules under different laws and making sure that they're in compliance with each checkbox on both of the laws. So to have a topically based rule set, I think makes the most sense at this point in time, and will certainly make the transition into having both a medical and an adult use market much smoother.
So that brings us to our main topic for today. I know it's been kind of a back and forth conversation addressing a lot of topics, but kind of the meat and potatoes of this whole MRA meeting was about the rule changes. I've been begging for these to happen since January when the law changed, because there were certain things that just kind of didn't make sense. You had an instruction booklet that was outdated. You had forms that only fit two different situations, even though there's a significant different number of situations that can be presented to the agency. So the more things are fleshed out and specific to those different types of scenarios, I think it's, again, more efficient and really streamlines the process. So I think the one takeaway from the application changes is that these were made to better fit the changes in the law that happened back in January 2019. It better fits with what the law actually requires the agency to check for from each applicant and each company. And it also just streamlines the entire application process, reduces, at least initially, a lot of the clutter that was being sent to the agency initially. And so I think just kind of, we're trending in a positive note I think since the MRTMA has kind of been passed, Prop 1 passed, and a lot of things have been kind of falling into place since then. Just as with every new industry, a lot of things are taking time. And so the more we're patient, the more we also help one another out in this process. I think it's all for the better. So Jennifer, do you want to kind of go through at least some of the changes, and we can go back and forth? And
Sure. So I think one of the biggest changes that we're seeing, and this was done really without much fanfare, but earlier this week, the department released a whole set of new MMFLA application forms. So when you would go onto the MRA website, suddenly there's new application forms, and they really hadn't explained them yet, but that's the purpose of the public hearing, was to give a little bit more guidance. So now, just the differences between the two. Under the old application, you had basically three types. You had an entity pre-qualification application, you had a supplemental application for the owners, or if you had a holding company or anything like that. And you also had a facility license application, which kind of talked more about your business practices. The new application, there's now substantially more application forms for you to pick from. So you could have an entity application. So if I wanted to have, Nick and I created a business, and we created N&J LLC to be the provisioning center applicant, then we could use that application. If I just wanted to run my own provisioning center, then I could use a sole proprietor pre-qualification application, and I wouldn't even need to really get an entity. We still have a supplemental application, but they've been broken up now into two separate formats. So we've got the supplemental application for individuals and a supplemental application for entities. So those holding companies, now they have a separate application that they have to fill out. And then we also have the facility license application. So there's a lot more documents to this new structure, but it actually makes things easier, I think. What do you think, Nick?
Yeah, because I think before with, step one, you had two different types. It was either you're a company or you're an individual applying for a license. And then if you were a company or an individual that had a membership interest in a company, you would use that other form. Now it kind of, it makes it a little bit more practical. There are two main applications, one if you're a company, one if you're an individual applying. And then if it's a company, you either, and you're an owner of that company as a company, it gets a little convoluted, but you file a supplemental application. So there's a lot of new acronyms: AEPA, SPPA, SEPA, SIPA, and FLA. But really, it's making more of those scenarios actually fit as to what the MRA has been seeing. Along with that, they kind of changed the fillable forms around a little bit. They plopped the new pretty MRA logo on top just to make sure it was up to date. But it really does make a big difference, I think, as far as the information and how it's received by the people that are filling out the application, as well as after it's submitted by the actual people who are reviewing it. So I think, baby steps with this, but it's definitely going to help out in the long run. Other than the forms being changed, though, to make it fit different scenarios in a better way, there were also some big news about what exactly actually has to be gathered and looked at from the agency, and I think that makes a big difference.
Absolutely. The biggest thing that I'm seeing here is a reduction in the amount of information that you have to provide, Lara. So as you may recall, you had to provide 36 months of bank statements.
3 years.
3 years of bank statements.
And that's a problem. I think, sorry, I get excited about this, right? So some banks don't carry that information electronically for more than a year. Some people just aren't expected to or don't keep track of all of this stuff and save it. And so it creates a problem when, especially when you have tens or hundreds of bank accounts, getting 3 years of them is significant compared to getting 1 year. And I think that what the agency determined is that, let's get a year, let's get this in front of us at first, and we'll start looking at it. If one or more of these accounts raises any red flags, we might ask a question or two about it, or we might, and they have the ability to go back another year or for that full 3 years to allow them to do that. But I think what they decided, and this is my opinion, was just that they were getting so much paperwork from so many months, and a lot of the times it didn't end up mattering or make sense for them to ask for that much stuff up front. And so I think it's still within their purview to go and get all of that information, but they're not requiring it at the outset.
I would agree with that. So from 3 years to a year, that's a substantial reduction in the amount of documentation you have to compile in order to hit submit to your application, which certainly speeds up the processing time and hopefully reduces the overall time needed by the analysts to review your bank statements. So certainly a good thing there. Additionally, for real property, they indicated that if you are a supplemental applicant and you have real property, before you had to provide every deed, lease, land contract, all the documentation associated with your ownership in any real estate company, or any real estate period, sorry. So your home, any rental properties, if your business has a property that you are on.
If your business has one, right? It went basically infinite.
Right.
There was no stone left unturned based on how the disclosure was kind of written and what we had seen the agency kind of ask. And now, they weren't making a list and checking it and making sure every single one was submitted at that point, but the way it was worded and the way the statutory requirements were labeled gave them the power to do that. In this case, though, they're taking a little bit more of a inclusive approach where they're saying only tell us about real property if it's being used for capitalization, so you have those minimum amounts that you have to show the state in order to be able to operate and maintain the business. So only use it if it's being used as capital, or you have to disclose it if it's the actual proposed facility location. So I think what this change from any and every deed, lease, land contract, purchase agreement, easement, so on and so forth, is that they're really narrowing it down to the financial part of it. If you're actually sourcing money from a property, or if you're actually going to use it for the proposed facility, that's when you have to give us the proof of your deed or the lease and all of that stuff. So I think they're similar to the 3 years versus 1 year bank statements. They're saying, they're really narrowing the scope to what matters for the purposes of them to actually pre-qualify you and pre-approve you.
Right. And finally, it's a smaller change, but it's an important one nonetheless. Tax returns. You still have to provide 3 years of tax returns. That part has not changed. That being said, part of the disclosure stated that you had to list every tax jurisdiction where you lived or you had to pay taxes in for the last 7 years. So people had to remember, where did I live for the last 7 years? Where did I pay taxes? Did I have to pay a city tax there? Did I have to pay, you had your state tax, you have the IRS, of course. So you have to list all of these out. That can be a little bit time consuming, especially if you've moved around a lot, or you had certain city taxes in certain locations, etc. Now, they only require you just to show your last 3 years of taxes, and they don't ask you about the last 7 years of your taxing jurisdictions, which certainly makes life a little bit easier, especially for those people who have moved around a lot. So certainly good changes all across the board. The biggest takeaways, I think, would be that there are new application forms that are structured specifically for what type of entity or individual you are in applying for a license, reduced amounts of financial accounts that are required, reduced amount of real property interests that are required to be disclosed, and a reduced amount of taxable jurisdictions that you have to disclose. So all good things. I think it's overall going to speed up the process, and I'm looking forward to seeing how they take the MMFLA application and make some changes now to the new adult use application.
Me too.
All right, well, I think that's it for today. As always, we'll be coming at you every week to tell you about the newest updates and the news from Michigan and across the country. If you have any questions, leave us a comment on Facebook or on YouTube, and we'll catch you next week. Bye.